Hey everybody, welcome back to the channel. We have an update for you. We're going to continue and try and provide updates for you in the wake of the Bruin decision on all things litigation within the Second Amendment community. We have Chuck Michel on. He is senior partner at Michel & Associates. He is volunteer president of the California Rifle and Pistol Association. Chuck, thank you for taking the time to be with us here today.
Thanks for having me, guys.
So I guess we can just jump right into it. Wanted to touch on two things right now that are making their way through the courts. First of all, the CRPA lawsuit, Bolin v. Bonta, dropped earlier this week. It's a challenge on the handgun roster. I've already made a video on it kind of describing some of the background and how this got started. So is there any further insight specifically to the CRPA lawsuit that we are looking to get answered in this case?
There are a lot of California gun control laws that do a lot of damage to your Second Amendment rights, but the roster is up near the top of that list because it has deprived California gun owners and wannabe gun owners of a choice of among thousands of handguns that consumers across the country have access to, can buy, but California has eliminated 80–90% of all handguns that are sold in the country cannot be sold in California. And it has nothing to do with safety or a handgun being unsafe. All of the guns that are available to consumers across the country, even if they're not on the roster of handguns that are designated to have passed the tests of the Unsafe Handgun Act, can be purchased by law enforcement and possessed and used by law enforcement. So this was never really about safety. It was always about limiting consumer choice and hopefully one day maybe eliminating all or most handguns and making it impossible and making it more difficult for people to get involved in the shooting sports. And this is a problem in multiple respects. I mean, not every handgun fits every person. You have to have consumer choice in order to be able to buy a handgun that is appropriate for your individual stature or circumstances or hand size or whatever your situation may be. And a lot of those choices have been eliminated. So, and then to top it off, they mandated microstamping on any new handgun. So you can't get the latest, greatest, safest, most technologically advanced handguns in California because they can't get on the list unless they have microstamping. And none of the manufacturers will put in microstamping. It's effectively impossible. Hence, we don't get any new guns coming on the list, but more and more guns keep dropping off. If that's not a Second Amendment violation because you don't have the choice for your individual circumstances to buy a commonly owned firearm that's owned by millions of people across the country, well, I don't know what is. But the reality is, post-Bruin, a few cases have been litigated and judges are back to their old tricks in many situations. They are trying to say that the right to keep bear arms is not implicated by certain laws, or that there are historically analogous laws that are similar to modern day laws, even though there are no such thing. But those were the steps that the Bruin case requires courts to take in order to determine whether a gun law is constitutional or not. So it's not. We're not going to be able to just mail this in. This is going to be a continuing fight, tooth and nail, scorched earth, because Gavin Newsom wants to be president, and he is pushing his agenda as hard as he can to pass every law that he can, and to try and come up with every excuse that he can give courts to uphold the laws that he's passed over the years that now are subject to this new test and should be struck down. So we're looking forward to taking out the hammer. We have a new tool now, thanks to Bruin, taking out the hammer and hammering Gavin Newsom and his cronies into constitutional submission and striking down a number of laws, not the least of which is the roster.
And these processes, I mean, they don't happen overnight. I don't think that there's any illusion out there that these lawsuits are going to be decided on tomorrow. And even if they were, they would assumably be appealed to the next level of the judicial system. However, there are functions within the judicial system that we can see change to overnight. So I was just curious on your perspective, any kind of prospect for injunctive relief or a temporary restraining order while this case gets litigated?
Yes, in almost all of our new cases and old cases, we will be seeking injunctive relief early on in the case. There's not a whole lot. Typically, when you file a case, you file your complaint, they file their answer, you get into there may be some motion practice at the beginning, which might be an injunction or a motion to dismiss. Then you get into discovery, because most cases involve factual disputes. And so you've got to determine what the facts are so that you can then get to the last part of the case, which is going to trial or a motion for summary judgment, some kind of thing that cuts off the case and ends it, and then ultimately results in a judgment. Well, in this case, there's not really a lot of facts. It's really just a question of law and constitutional law. So yes, we will be going in and trying to shorten the time frame on these lawsuits by seeking injunctive relief early and appealing that if necessary, to the Ninth Circuit and the Supreme Court. So hopefully we will get some quicker results than we might otherwise have been getting in some of the other cases that were being litigated before the Brewer decision came down.
Yeah, and that could be a huge deal. I mean, you're talking about effectively taking the law away while the lawsuit is being litigated. So that could be a really good effect that you see just with an appeal for injunctive relief. Speaking of injunctive relief, and something that we saw. Not necessarily injunctive relief, but we did see a law get stricken down for a week due to St. Benitez, the Duncan v. Becerra case. There's been some movement on this lately. I wanted to pick your brain a little bit. Obviously, it was at the Supreme Court level, and due to the Bruin decision, they put it back down to the Ninth Circuit. We've recently seen the Ninth Circuit request supplemental briefings. I was hoping you could just describe, kind of what this means. I'm assuming, it's another stalling tactic, right? They see a losing case on their side. They're going to try and draw this out to keep this law in place as long as possible. Is that your take on it?
Well, to some degree, in some of the cases, yes, but not all. Remember, as we waited for Bruin, we litigated the Duncan case on the 10-plus round magazines. We won in the 3-judge Ninth Circuit panel. They then appealed it en banc to the 11-judge panel. We lost in front of the 11-judge panel because the Ninth Circuit is still stacked slightly against us, although not as badly as it used to be, thanks to Trump. But so when we lost in the 11-judge panel, we asked the Supreme Court to do that decision. While that decision is being reviewed by the Supreme Court, the Rhodey case challenging the ammunition background law, the Flanagan case challenging LA County's good cause requirement to get a CCW, the Rupp case challenging the state's black rifle ban, and a couple other cases were all stayed. They were frozen, waiting to see what would happen with Duncan. So when Duncan was reviewed by the Supreme Court, and the Supreme Court said, hey, in light of what we just said in Bruin, your 11-judge panel, that decision is vacated, wiped out. Redecide the case now in light of what we said in Bruin. So now the en banc panel is trying to decide what to do. Should it back to the 3-judge panel? Should they remand it back down to the district court, which was Judge Benitez? And meanwhile, in the other cases, they already have, like in the Roop case, they've remanded that back down to the district court to be argued in light of Bruin. There's also a companion case, Miller case, that struck down, Judge Benitez struck down the black rifle ban. That's been sent back down to the district court to be rebriefed. The Rhodey case is being rebriefed. Basically, all the cases have been sent back down the line to be rebriefed and say what the impact of the Bruin decision is. In some cases, that's a way to draw things out. In other cases, it's a way to just make the record straight about what the effect of the Bruin decision is. But all those cases are now back in play, and we are preparing those briefs, getting ready to fight to keep or get a win in those cases now that we've got the Bruin decision backing us up.
So definitely sounds like good things coming down the road with the Bruin decision, but a little bit of a reset button. We're going to have to hear a lot of these cases again. Chuck, I want to thank you for coming on and sharing these updates with us. And to everybody, you know, there's going to be a lot more information coming out soon. These cases aren't going anywhere. Likely we will see a lot more cases come up because of the Bruin decision in the future. So you're definitely going to want to be plugged in. One way to stay plugged in is to subscribe to the channel. You'll get updates every week from CRPA. You can also visit us at crpa.org, where we will continue and post updates on there. And also hit a share and like on these videos. It really helps with the algorithms to get these videos out to as many people as possible. So we will see you next time with the next update.